Let me be the first to welcome you. My name is Shant Boyajian. I'm a partner with the Nossaman Law Firm. My colleagues and I this morning or afternoon, depending on your time zone, are presenting a session on federal policy updates and their implications on transportation funding. This topic is an important one, and we're going to be giving you an overview of some of the things that have developed over the last 9 or so months, as well as some practical tips on how to be thinking through this and how these issues may develop because they are continuing to do so. Before we get into the substance, maybe I can turn it over to Anne-Therese and then to Erin to introduce themselves, please.
Sure, thanks, Sean. My name is Anne-Therese Schmid. I'm a partner in Nossaman's Washington, D.C. office, along with Shant, and I practice in our infrastructure practice group. My practice primarily focuses on representation of state and local governmental agencies and alternative delivery procurements and contracting for major surface transportation projects. I also advise clients on compliance with federal regulations and policies when their programs and projects include federal funding and financing. Erin?
Hi, my name is Erin Lee. I'm an associate attorney in LA office with Nossaman LLP, and I'm supporting partners in various projects across highway, transit, social infrastructure, and water projects.
Thanks so much, Anne-Therese and Erin. My name is Shant Boyajian. As Anne-Therese said, I'm a partner here in the DC office in our infrastructure practice group. Like Anne-Therese and Erin, I represent public agencies and other entities in the infrastructure space across the country in a variety of different significant projects and just transportation challenges generally. This often involves alternative delivery methods, strategic advising, and specifically focusing on federal compliance and policy-related matters. Before joining the firm about 10 years ago, I spent several years on Capitol Hill where I worked on the 2012 and 2015 transportation authorization bills. And so these issues that we're going to be discussing today are near and dear to my heart. Before we get into the substance, let me just say we have a lot of material to cover. Given the limited time that we have, there's necessarily going to be, some level of detail that we're not able to go into on each of these topics. But if you have any questions at all that we're not able to address during today's session, please feel free to reach out to us. We would be happy to speak with you about that. Also, we have written fairly extensively on many of these topics. If you'd like to review some of our written material, please go to nossaman.com and click on Thought Leadership at the top of the page, and you'll be able to see some deeper dives into a lot of the topics that we're discussing today. Some housekeeping matters. First of all, this is being recorded, and we will email you a link to download the slide deck as well as a copy of the recording after the session concludes. In addition, if you have any questions, please use the Q&A button at the bottom of your screen. We're going to be trying to get through the material, just given the volume that we have, but we are reserving time at the end to answer any of the questions you may have. And I know several of you submitted questions in advance as well, so we thank you for that. But as I said, if we're not able to get to everything, please, feel free to reach out to us. We want to be a resource to you. In addition, we would greatly appreciate you completing the survey. That will be part of that email that you get after this is over. It helps us understand what your interests are, what your needs are, what we can do better next time, topics that you're interested in. So please, that would be very helpful. And finally, for our fellow attorneys in the meeting, if you provided your bar number when you registered, you should receive an MCLE certificate via email within a week. So with that, today we're going to be talking about generally updates to federal funding and financing with respect to federal infrastructure programs, in particular with respect to the National Electric Vehicle Infrastructure, or NEVI, formula program, the Neighborhood Access and Equity Program, and the TIFIA program, as there have been some specific developments with respect to those three in particular. We're also going to be doing a deeper dive into a lot of the federal regulatory and policy updates that we have seen over the last 9 or 10 months. And this includes directives from the White House, from different federal agencies, regulatory updates, as well as relevant litigation. So to kick things off, earlier this year, we saw a flurry of activity beginning in January after President Trump was inaugurated. There were many executive orders that came out and associated OMB memoranda that were issued in late January. We're not going to go through each of these in detail, but a lot of the focus was originally on the quote-unquote Green New Deal and funding related to quote-unquote Green New Deal activities. As a result, for transportation, this really focused primarily on EV-related infrastructure, which had been provided through the Infrastructure Investment and Jobs Act, otherwise known as the Bipartisan Infrastructure Law. And this is the particular nexus to the NEVI formula program. In addition, over the summer, we saw this kind of continue through implementation of the One Big Beautiful Bill Act, specifically with respect to the Neighborhood Equity and Access Program. And so we'll talk about that in a few minutes as well. Specifically with respect to the NEVI formula program, on February 6th, the Federal Highway Administration issued a letter to all state DOTs suspending the NEVI formula program. This was the subject of a lawsuit almost immediately, where the court issued a preliminary injunction enjoining the US DOT from withholding the NEVI formula funds for the 14 states that were participating in that lawsuit. This brings us to some additional recent developments with respect to the NEVI formula program. The government accountability has begun kind of taking a particular look at this, but before we get into the specific findings that GAO made, let me just say by background, the GAO is an independent agency within the legislative branch of the US government, so it works at the behest of Congress. And GAO is one of the tools that Congress uses in its oversight over the administrative branch's implementation of funds that Congress has appropriated. So GAO took a look at this issue, kind of the US DOT's withholding of NEVI funding, and on May 22nd of this year found that this was an unauthorized action by the US Department of Transportation, specifically finding that it violated the Impoundment Control Act because it sought to withhold funds that had arisen by operation of law. So that was the activity that GAO, an office of Congress, took on May 22nd. Subsequently, the Office of Management and Budget within the White House advised the US DOT in June to disregard the GAO determination. GAO subsequently found in July that the Federal Highway Administration lacked a fully defined set of performance goals for both the NEVI program and the associated charging and fueling infrastructure program, which is sort of the discretionary grant program that correlates with the NEVI formula program. Let me turn it over to my colleague Erin to talk a little bit more about the NEVI program and its recent developments.
Hello, everyone. Let me begin with a brief overview on the NEVI formula program. So NEVI program was established by the Infrastructure Investment and Jobs Act, which was enacted in 2021, and it's authorized under paragraph 2 under the IIJA's Highway Infrastructure Program. So the NEVI formula program provides $5 billion funding to states so they can use the funding to deploy electric vehicle charging infrastructure and to establish an interconnected network to facilitate electric vehicle data collection, access, and reliability. Federal Highway Administration has been in charge of issuing various guidances, with the initial guidance being published in 2022. And the main goal of these guidances have been encouraging the states to build a convenient, affordable, reliable, and equitable national EV network. Federal Highway Administration issued a new guidance this year on August 11th. This new guidance, called New Interim Final Guidance, supersedes all previous guidance documents, such as those documents listed in the screen right now. And among other things, it supersedes June 11, 2024 NEVI Formula Program Guidance, which provided a really detailed and specific set of requirements for states to follow in their deployment plans. One of the major changes under the new guidance is that the approval process for states' EV deployment plan has been significantly simplified. So the new guidance only requires these three components in states' deployment plans, which is a description of how the state intends to use NEVI program funds for each fiscal year. Second, a community engagement outcomes report. And lastly, a description of physical and cybersecurity strategies. Under the old guidance, states were required to provide more specified and detailed plan, which included, among other things, state agency coordination, civil rights requirements, existing and future condition analysis. Another major change is that now states have flexibility to determine the appropriate distance between stations, charging station along AFCs, alternative fuel corridors. Before, under the old guidance in June 2024, states were required to keep the distance to be 50 miles or less. And another major change is that now states have more flexibility in determining when their system is fully built out. So for the background, NEVI program allows states to use the funding for public roads once it is determined that the EV infrastructure has been fully built out. Before, under the old guidance, such authority has been reserved to the Secretary of Transportation. Under new guidance, now states have authority to make the preliminary determination, which will be subject to Federal Highway Administration certification. And some other changes include minimizing the content required in state plans to statutory and regulatory requirements, such as community engagement and consultation requirements. Also, states are not required to consider electric grid integration, renewable energy, and alignment with electric distribution interconnection processes as much as how much they were required to consider them under the old guidance. And some other changes are that states are now encouraged to select charging locations where the charging station owner is also the site host. And now the states are not required to address consumer protections, emergency evacuation plans, environmental siting, resilience and terrain consideration, as well as they're not required to conduct community outreach and participation anymore. And it should be noted that states still have flexibility and freedom to conduct or include any of these analysis in their plans if they choose to do so. It's just that under the new guidance, these are not required anymore for the plans to be approved. We're going to put out an e-alert with more details on the new NEVI guidance, so stay tuned.
Thanks so much, Erin. So as Erin noted, the IIJA authorized as well as appropriated $1 billion a year for the 5-year period in which the IIJA authorized federal transportation programs. So there's $1 billion authorized and already appropriated under the IIJA for fiscal year 2026. So right now, as for those of you who occasionally read the news, you may have heard that there's a government funding disagreement, and we don't currently have a path forward on funding the government past the end of this month when the current CR expires. However, the House and the Senate have both drafted versions of their transportation appropriations bills for fiscal year 2026. The Senate version does not touch NEVI funding. As I mentioned, the IIJA already provided $1 billion for fiscal year 2026 for the NEVI formula program. However, the House version of the FY26 appropriations bill actually redirects that $1 billion from the NEVI program to pay for Federal Aviation Administration facilities and equipment. So one additional change that I want to talk about here with respect to a particular program is the Neighborhood Access and Equity Program. This is a discretionary grant program created in the Inflation Reduction Act. So not the IIJA, but the subsequent Inflation Reduction Act created this program. And in the One Big Beautiful Bill Act that was enacted via reconciliation procedures earlier this year, Congress rescinded the unobligated balances of the amounts for the Neighborhood Access and Equity Program. So there were $3.2 billion in grants under this program that had been awarded. 2.4 billion of those had been unobligated at the time of enactment of the One Big Beautiful Bill Act and were rescinded. There were approximately 78 projects that will lose funding as a result of this under the Neighborhood Access and Equity Program. However, a related program, just to be clear, the Reconnecting Communities pilot program, which was for similar purposes established in the IIJA, not the Inflation Reduction Act, that is still funded. One other very notable change with respect to federal funding and financing programs is the Transportation Infrastructure Finance and Innovation Act, otherwise known as TIFIA. And this is a federal financing tool that has seen incredible success in leveraging federal financing assistance to create public infrastructure across the country. In July, Secretary Duffy announced that the percentage of eligible project costs that can be financed under the TIFIA program is being increased from 33% to the 49% that is and has been statutorily prescribed for decades. As a matter of policy, before this, US DOT had not leveraged TIFIA to the full extent that it was capable of statutorily. Previously, only rural and certain transit-oriented development projects were eligible for that 49%. But now, as of July 7th, any qualified project is eligible for 49% participation under TIFIA. So some practical tips just with respect to transportation funding and financing. Please, please, please review the notices of funding opportunity closely, because it is likely, unless this is for a program that has been sort of a second bite at the apple after this administration came in, it's very likely that some of the procedures, some of the substantive requirements have changed. And even for kind of second and third, opportunities within this administration, please continue to take a look at those terms very carefully, because these issues are constantly evolving. Two other points of caution. First, grants that have been awarded but not obligated. So that means the grant may have been selected and publicly noticed, but that the actual grant agreement itself has not been signed. USDOT could still amend or cancel the grant. And there have been, there's been significant media coverage and publication from USDOT about the volume of grants that fell into this category when they came in at the beginning of in the middle of January. I think they noted that there were several thousand grants that had been selected, but still had grant agreements that needed to be executed from the last administration. So they've been reviewing them and, kind of systematically working through whether or not to actually move forward with obligating those grants or canceling them. So please be aware of that. In addition, for those of you who have grants that are obligated, please note that these may still be amended or terminated, because every federal grant incorporates by reference the Super Circular 2 CFR Part 200, which has a termination for convenience clause in the favor of the federal government. So the federal government, even for grants that have been obligated, retains broad discretion with respect to how to implement that and whether or not to terminate a grant if the recipient fails to comply with the terms and conditions of the award. So next, we're going to talk about some transportation policy updates. I'm going to turn it over to my partner.
Thank you, Sean. Today, I'm providing a high-level overview of federal funding and policy issues related to highway and transit projects. And although many of the policies being discussed today are also relevant to other operating administrations within USDOT and generally to other recipients of federal grants and loans. So even though we're focusing on highways and transit, a lot of this can be extrapolated to other types of projects. Also with the caveat that, to be sure, some of the operating administrations under USDOT are moving faster than others, and some OAs have different opinions than others, but generally the topics that we're covering today are relevant across USDOT. So just moving into our executive orders, we're going to focus on these 5 executive orders and the policy, guidance, regulatory changes, and litigation that have arisen from them. So the 5 executive orders are EO 14151, ending radical and wasteful government DEI programs and preferencing, EO 14159, protecting the American people against invasion, EO 14168, defending women from gender ideology, extremism, and restoring biological truth to the federal government, EO 14173, ending illegal discrimination and restoring merit-based opportunity, and EO 14224, designating English as the official language of the United States. So the majority of these EOs were issued on the administration's first day in office, January 20. The exceptions are EO 14173, which was issued on January 21, and EO 14224, which was issued on March 1. So in case you're looking for them, that's the timeline for when they were issued. Moving on, at the outset of the administration, USDOT issued 2 policy documents on January 29. One of these 2 policy documents is an order directing rigorous economic analysis and positive cost-benefit calculations and requiring agencies to avoid adverse impacts on and maximum benefits for families and communities. In addition to that, Order DOT 2100.7 also requires that USDOT prioritize projects that adhere to the items on this list. They have to adhere to Buy America requirements, utilize user pay models, direct funding to local opportunity zones, mitigate impacts on families, give preference to communities with marriage and birth rates higher than the national average, prohibit fund recipients from imposing vaccine or mask mandates, and require local compliance or cooperation with federal immigration enforcement. So again, these are the types of projects that the administration will prioritize. Also on January 29, USDOT issued a second policy document, which is a memorandum directing the Office of the Secretary of Transportation and the operating administrations to rescind certain USDOT orders, directives, rules, and guidance, specifically those orders and other documents that are related to climate change, greenhouse gas emissions, racial equity, gender equity, diversity, equity, and inclusion and accessibility goals, environmental justice, and the Justice 40 initiative. In follow-up to the January 29 memorandum, we just want to note that Secretary Duffy issued a letter to all recipients of USDOT funding that effectively implements externally the direction made by the secretary to his office of secretary and the operating administrations in that January 29 memo. So this letter was issued on July 2, and it indicates that US DOT will no longer enforce and considers to be null and void and of no effect any orders, directives, rules, regulations, notices, guidance documents, funding agreements, programs, or policy statements that relate to that same list of items. So that relate to climate change, greenhouse gas emissions, racial equity, gender identity, DEI goals, environmental justice, and Justice 40. So this appears to be sort of a blanket notification that US DOT will not enforce these orders, directives, rules, regulations, etc., even if not formally rescinded at that point. So moving into DEI and focusing on diversity, equity, and inclusion for a moment, United States Attorney General Pam Bondi issued a memorandum on February 5th, indicating that the Department of Justice's Civil Rights Division will investigate, eliminate, and penalize quote unquote illegal DEI preferences, mandates, policies, programs, and activities in the private sector and at educational institutions. Of note, in a footnote, the Attorney General did clarify that her memo does not prohibit educational, cultural, or historical observances that celebrate diversity, recognize historical contributions, and promote awareness without engaging in exclusion or discrimination. After the Attorney General issued her memo on February 5, Secretary Duffy followed up on April 24 with a letter to all recipients of US DOT funding. This letter is widely known as the Follow the Law letter. And the letter states that policies or practices designed to achieve diversity, equity, and inclusion goals presumptively violate federal law, and federal funding recipients are precluded from allocating such funding based on suspect classifications. This letter also introduces US DOT's directive that funding recipients cooperate with and not impede US Immigration and Customs Enforcement and Department of Homeland Security enforcement of federal immigration law. Consequences of noncompliance with the Follow the Law letter are set forth in the letter as civil and criminal liability, enforcement actions, comprehensive audits, recovery of funds, and or termination of funding. Continuing on with DEI-focused discussion, subsequent to the Attorney General's February 5 memo, Deputy U.S. Attorney General Blanche issued a memo on May 19th indicating that one of the best ways of accomplishing the outcomes of the February 5 memorandum is through vigorous enforcement of the False Claims Act. This memo also encourages private parties to file lawsuits and litigate claims pursuant to the FCA. Those are known as qui tam actions. And after many questions and concerns across various sectors were raised regarding how the Department of Justice would interpret what is quote unquote illegal diversity, equity, and inclusion, Attorney General Bondi issued a memo on July 29th to provide practical recommendations to minimize the risk of violation of federal anti-discrimination laws. This memo indicates that using race, sex, or other protected characteristics for employment, program participation, resource allocation, or other similar activities, opportunities, or benefits is unlawful, except where such discrimination satisfies relevant judicial scrutiny. The memo goes on to warn against unlawful proxy discrimination, which it defines as facially neutral criteria that function as proxies for protected characteristics, if designed or applied with the intention of advantaging or disadvantaging individuals based on protected characteristics. The memo extends scrutiny to entities that receive federal financial assistance and also other entities that are subject to federal anti-discrimination laws, such as educational institutions, state and local governments, and public and private employers. So moving to enforcement, it's been reported that the Department of Justice has begun to issue what are called civil investigative demands to federal contractors and federal grantees seeking information related to their diversity, equity, and inclusion programs. So this relates to the False Claims Act, and violations of the FCA can arise when a recipient knowingly submits a false claim to the federal government. Civil investigative demands are issued under the FCA if the Department of Justice has reason to believe the subject of the CID has information relevant to a False Claims Act investigation. So in other words, CIDs are issued before the Department of Justice has formally brought an FCA action against the contractor or grantee, or as part of an investigation brought by a whistleblower pursuant to the qui tam provisions of the FCA. The civil investigative demands are used to demand production of documents and electronically stored information, responses to written interrogatories, and other evidence. So again, they're commonly used to investigate potential FCA violations and obtain discovery before litigation starts. And the information obtained can be used to support the Department of Justice-led litigation or to intervene in a qui tam action. Note that pursuant to the U.S. Attorney General's February 5 memorandum and Secretary Duffy's Follow the Law letter, operating administrations at USDOT have started to require certain certifications pursuant to grant agreements that recipients do not operate any programs promoting quote unquote unlawful diversity, equity, and inclusion programs. So in today's context, these False Claims Act investigations may be based on challenges to such certifications made by a federal recipient. So just really briefly to go over the elements of the False Claims Act, and False Claims Act is very complicated, so this is a very high level review, but it has three elements. There's a three-part element test that includes falsity, so proof that a defendant submitted or caused submission of a false or fraudulent claim to the federal government. There's knowledge or intent, which is demonstration that the defendant had knowledge of the falsity, meaning it either had actual knowledge of the truth or falsity of the information, or acted with deliberate ignorance of the truth or falsity of the information, or acted in reckless disregard of the truth or falsity of the information. The last element to the False Claims Act, to a False Claims Act claim, is materiality. So demonstration that the false statement was material to the government's decision to pay federal funds or award a federal contract. Violators of the False Claims Act can be subject to damages, or potential debarment, reputational damage, and private civil suits. False Claims Act damages include treble damages, or up to 3 times the total value of the contract. Plus, there's also per claim penalties ranging from $14,000 to $28,000 each time a contractor bills the government. When we're talking about private civil suits, those could include shareholder class actions. In addition, False Claims Act violations and settlements under the FCA are reportable when seeking further federal funding. We just want to note that generally past False Claims Act enforcement has focused on recovering government funds lost to fraud rather than on oversight of federal fund recipients' programs, which seems to be the purpose of these investigations. And to be clear, it's not clear who the recipients of the CIDs have been, but recall that under Executive Order 14173, there was a requirement that each agency of the federal government identify up to 9 potential civil compliance investigations of publicly traded corporations, large nonprofit corporations or associations, foundations with assets of $500 million or more, state and local bar and medical associations, and institutions of higher education with endowments over $1 billion. Finally, getting to the most recent update, on August 28th, the President issued a memorandum directing the Attorney General in consultation with the heads of federal agencies to investigate whether federal grant funds are being used to illegally support lobbying activities. As a reminder, the Byrd Amendment prohibits any recipient of federal contracts, grants, loans, and cooperative agreements from using any appropriated funds for lobbying on those topics. In other words, attempting to influence officers and employees of an agency or a member of Congress or an employee of Congress in connection with a federal contract, grant, loan, or cooperative agreement, including the extension, continuation, renewal, amendment, or modification of the same. The Attorney General must report her finding in 180 days. So we'll remain on the lookout for further memoranda, letters, or other directives related to this topic in the near future, but think we should anticipate, seeing some directives from the Attorney General's office coming out related to this, and potentially from USDOT itself as well. Turn it back over to Sean to go over some of our regulatory updates.
Thanks, Anne-Therese. So as Anne-Therese just talked about, there's been a lot of action, both directly from the White House and from the administration, implementing policies that impact all of our day-to-day work in the infrastructure space. So what I'm going to talk about now are some of the actual regulatory updates that impact these areas. The first of which is with respect to the National Environmental Policy Act. And before I talk specifically about what USDOT has done here, I want to just give a little bit of context. So backing up, when NEPA was implemented about 55 years ago, it created the Council on Environmental Quality within the White House, otherwise known as CEQ. And CEQ was established for the purpose of assisting and advising the president on NEPA implementation. Over the years, CEQ has issued guidance and regulations to standardize how all federal agencies conduct NEPA reviews. So kind of a one-stop shop, providing generally applicable guidance across the federal government. However, two recent federal court decisions have called into question CEQ's statutory authority to actually issue those binding regulations across the government. These are Iowa versus CEQ and Marin Audubon Society versus FAA. As a result, on February 19th of this year, the Chief of Staff for CEQ, Catherine Scarlett, issued a memoranda to all the heads of federal agencies with respect to CEQ's implementation of NEPA, instructing federal agencies to establish or revise their own NEPA implementing procedures within 12 months. So that was February 19th. Less than a week later, on February 25th, CEQ published an interim final rule in the Federal Register rescinding CEQ's NEPA regulations. So basically eliminating that standardized guidance on NEPA implementation across the federal government. This is where DOT Order 5610.1c comes in. So in response, USDOT issued this order entitled Procedures for Considering Environmental Impacts to basically bring everything up to date and comply with NEPA. This order, prior to being updated, had last been updated in 1985. And so USDOT's update of this order was to bring it current through SAFETY-LU, MAP 21, the FAST Act, IIJA, FRA, and then the EO 14154, Unleashing American Energy updates. In addition, because there is a separate statute in 23 U.S. Code Section 130 that provides some additional respect to Federal Highway Administration, Federal Railroad Administration, and Federal Aviation Administration, those regulations were retained due to the specific requirements of that action. In addition, 23 CFR Part 771 was modified to remove cross-references to the CEQ regulations, since those have now been rescinded, and to make updates per FRA, the Builder Act, and streamlining provisions of the IIJA. We've provided links here, and again, you'll receive this slide deck by email, so that you can go and find some additional guidance with respect to USDOT's NEPA procedures. In addition, there have been several Federal Highway Administration and Federal Transit Administration regulations that have either been rescinded or amended. So on May 30th, 2025, FHWA rescinded rescinded or amended 16 different regulations. I'm not going to go through these individually, but they're here for your reference, and you can look into them or ask us any specific questions that you may have about them by email. And then in addition, the Federal Transit Administration has issued rescissions or amendments to several regulations, about a dozen regulations, including those related to charter service, major capital investment projects, organization, functions, and procedures of the agency, school bus operations, transit asset management, transportation for elderly and handicapped persons, and several others as well. So shifting gears a little bit to the U.S. Department of Labor, Office of Federal Contract Compliance, these are extremely relevant to the implementation of federal transportation funding and financing. Specifically, USDOL's Office of Federal Contract Compliance Programs, otherwise known as OFCCP, has historically implemented federal equal employment opportunity laws. Now, if you recall, Executive Order 14173, this is entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity, which the President issued on January 21st, 2025. This EO revoked Executive Order 11246, which itself prohibited covered contractors from discriminating in employment decisions based on race, color, religion, sex, sexual orientation, gender identity, and national origin, and required federal agencies to take affirmative action. And so as a result of EO 14173, the U.S. Department of Labor, OFCCP, initiated a rescission or a modification of its implementing regulations with respect to the EEO program. The comments were originally due on September 2nd. USDOL extended that deadline to September 17th, and the proposed rule has not yet been finalized. However, what we've provided here is an overview of the various topics, the cross-reference to the federal regulations, and whether or not this proposed rule would rescind or modify those particular topics. I'm going to turn it back over to Anne-Therese.
Thanks, Sean. Now turning to updates to the Federal Highway Administration's and Federal Transit Administration's grant agreements and their required flow-down clauses. As Sean mentioned, the spate of notices of proposed rulemaking issued by the FHWA on May 30 included one that proposes to remove 23 CFR Part 633 Subpart A, which requires recipients of FHWA financial assistance and their contractors and subcontractors to physically incorporate Form FHWA 1273 into contracts at every tier that expend those funds. Under the NPRM, recipients, contractors, and subcontractors may voluntarily incorporate Form FHWA 1273, although it should be noted that whether or not Form FHWA 1273 itself is incorporated into an affected contract, the recipient contractor and subcontractors will nonetheless be required to comply with all of the substance of the requirements currently included on the form. The comment period on this NPRM closed on June 30th. And we're waiting to hear if there's any updates from FHWA on that. In addition, the Federal Transit Administration has updated its master agreement twice during this administration. The first update was made on March 26th and generally addresses edits related to the deletion of references to gender identity, deletion of references to Executive Order 11246, which, as Shant just mentioned, was revoked by EO 14173. Deletion of references to U.S. DOT affirmative action regulations, which are found at 49 CFR Part 21. Deletion of references to U.S. Department of Labor affirmative action regulations, which Shant was just mentioning the rulemaking related to those. Those are found at 41 CFR Chapter 60. And deletion of references to environmental justice. In addition, there were revisions to the limited English proficiency provisions of the grant agreement and additions of certifications under Executive Order 14173, which we were just discussing in the context of the False Claims Act investigations that the Department of Justice has begun. The FTA Master Agreement was updated a second time on April 25th, and those updates included deletion of a provision requiring recipients to have a FTA-approved disadvantaged business enterprise program, but note that the grant agreement did retain other DBE-related provisions. And in addition, there was the addition of provisions requiring recipients to cooperate with federal officials in the enforcement of federal law, including cooperating with and not impeding U.S. Immigration and Customs Enforcement and other components and offices of the Department of Homeland Security in the enforcement of federal immigration law. And finally, I just wanted to note that FTA has recently issued 2 notices in the Federal Register related to guidance. First, on August 19th, the Federal Transit Administration provided notice of availability of new proposed guidance for the Capital Investment Grant Program. The proposed guidance is updated to implement changes to address direction under U.S. DOT Order 2100.7. That was one of those January 29 directives that came from US DOT, and the comment period closed for this on September 2. And second, on September 15th, the Federal Transit Administration provided notice of withdrawal of its environmental justice guidance. That's Circular 4703.1. The withdrawal of the circular is based again on Executive Order 14173, which revoked Executive Order 12898, which was the basis for these EJ programs, as well as Secretary Duffy's January 29 memorandum. So moving on to some litigation updates. First, we're looking at sorry, I'm off by one. King County versus Turner, which was brought in the Western District of Washington. In this case, local governmental entities are challenging new U.S. Department of Housing and Urban Development and U.S. DOT grant conditions. And as far as US DOT grant conditions, this is all operating administrations. It should be noted that later Health and Human Services was also added as a defendant under this case. A preliminary injunction was issued June 3, enjoining US DOT from imposing or enforcing new language and rescinding, withholding, canceling, pausing, freezing, blocking, terminating, delaying, or conditioning grants and nullifying new grant conditions in already signed grant agreements. Like the Nevy case that Shant spoke of earlier, the preliminary injunction only applies to named plaintiffs. And just a note on that for those who are kind of watching these things, a reminder that under the Supreme Court case Trump v. Casa, which came out in June. The Supreme Court ruled that federal courts lack statutory authority under the Judiciary Act of 1789 to enjoin executive branch policies as to non-parties. And this has sharply curtailed the use of what were called nationwide or universal injunctions. Thus, as we're going through these cases, you'll note that these preliminary injunctions and eventually permanent injunctions, if issued, would only be issued to the extent necessary to provide relief to actual named plaintiffs. The next case is State of California versus USDOT. This was brought in the District of Rhode Island. Under this case, the states are challenging Secretary Duffy's April 24 Follow the Law letter, specifically the immigration enforcement conditions and subsequent grant conditions. A preliminary injunction was issued June 19, enjoining USDOT from enforcing immigration enforcement conditions and withholding or terminating federal funding based on the immigration enforcement conditions. And again, the preliminary injunction applies only to the named plaintiffs. The next case is City of Seattle versus Donald Trump. This is actually the most recently filed case. This was brought in Western District of Washington. The complaint was filed on July 31, and USDOT recently filed its response on September 16th. This case challenges the executive orders themselves, EOs 14173 and 14168, claiming the language in the executive orders is overly broad and not reasonably related to any federal interest in the plaintiff's projects. The complaint cites concerns that the vagueness of what constitutes a quote-unquote illegal DEI program under EO 14173 creates False Claims Act exposure. And similarly, the complaint also cites that EO 14168 requires agencies to ensure grant funds do not promote gender ideology without actually indicating what promotion of gender ideology is. So we're waiting to see how this particular case progresses, since we just had the response filed September 16th. And lastly, we have Mid-America Milling Company versus Department of Transportation. This case was brought in the Eastern District of Kentucky. And just to note, this Mid-America Milling suit was filed under the prior administration, so it's been winding its way through the courts for quite some time, but there have been some updates under this administration. The parties jointly filed a motion for entry of a consent order on May 28th. And under that entry of consent order, they would stipulate that use of race and sex-based rebuttable presumptions in the determination of disadvantaged business enterprise eligibility is not supported by the Constitution as it is currently interpreted. It also stipulates the race and sex-based rebuttable presumption of social and economic disadvantage used in USDOT's Disadvantaged Business Enterprise Program violates equal protection under the Fifth Amendment's Due Process Clause. And the order asks the court to hold that use of DBE contract goals based on the race and sex-based rebuttable presumptions violate equal protection. Interveners are continuing to file under this litigation. So again, we're watching it and waiting to see what happens. I just want to make a few notes. A letter from Secretary Duffy to Governor Wes Moore of Maryland recently was issued, and it's regarding the reconstruction of the Francis Scott Key Bridge. But under that letter, the Secretary indicates that USDOT is revising its DBE regulations, so we should watch for that. If you've participated in some of our past DBE-specific webinars, we surmised that this would be a likely outcome based on the fact that DOT's DBE program is actually statutorily mandated. So stay tuned for notices of proposed rulemaking, and beyond that, inevitable discussion related to DBE program during the surface transportation reauthorization. It should also be noted that another case that addresses the use of race-conscious rebuttable presumption In the Small Business Administration's 8A program, a case named Heyerholzer v. Guzman recently petitioned for writ at the U.S. Supreme Court. So while Mid-America is going through its process, there is a case that is very similar that has petitioned for writ to the U.S. Supreme Court. We'll see if SCOTUS takes this case, but it would clearly have repercussions on Mid-America moving forward. And finally, just like Sean had some practical tips for the transportation funding and financing conversation, we've got some for the policy updates as well. You know, as the Office of Secretary of Transportation and the operating administrations complete reviews of their respective programs and policies, we encourage grant recipients to be on the lookout for direction from the applicable OAs in the form of notices of proposed rulemakings like we have been seeing, revisions or amendments to current notices of funding opportunity, as Shant mentioned, and rescission or revision of current or implementation of new guidance and policy documents like we recently saw with both the capital investment grant and the environmental justice circulars. In addition, operating administrations may opt to unilaterally amend executed grant agreements to comply with the administration's policies. This is what we've been seeing with some of those updates to particularly FTA's master agreements. And note that USDOT and congressional committees are currently seeking feedback regarding the next surface transportation reauthorization, noting that the current reauthorization expires on September of 2026. So if your organization, finally, if your organization receives a CID related to False Claims Act investigation, we encourage you to promptly notify your legal counsel to prepare the response and to not delay responding to any sort of inquiries related to False Claims Act. Sean, I'll turn it back to you.
Yeah, well, I just want to say thank you to everyone for sticking with us through this. I know it was a lot of information. I believe some questions have started to come in. Please feel free to continue to submit any questions that you have through the Q&A button at the bottom of your screen. We've got just over 30 minutes left, and I would expect that unless we have been absolutely crystal clear in a way that alleviates any potential question you may have in your mind about all of these topics, there are probably some things for us to discuss. So please submit your questions. And I'm going to turn it over to Erin, if you can maybe just walk us through what we've got so far.
Yes, we received a question. Is USDOT evaluating reestablishing funding to support creation of state infrastructure banks with significant funding of $2 billion to strengthen the TIFIA program? So I guess in general, we can address how these policy updates may be addressed during the reauthorization process.
Sure, I'm happy to take an initial stab at that, and then Erin or Anne-Therese, please feel free to supplement or disagree. So, you know, as we discussed, the real recent update from the USDOT has been with respect to moving TIFIA from the 33% cost share to 49% cost share. One thing that we have not seen recently is the use of TIFIA funds or the use of federal funds, broadly speaking, to establish state infrastructure banks. This is something that dates back a couple decades. I believe only a very small number of states have actually utilized federal funding to stand up state infrastructure banks. One of the key issues, the key questions around this policy area is whether you can essentially use a state infrastructure bank that has been capitalized with federal funds to essentially wash the federalization out of the project, so to speak. And by that, I mean, you know, essentially the way a state infrastructure bank would work is it's capitalized with funds, it makes loans. As it receives interest on those loans, it recapitalizes the bank itself, and it provides almost a revolving fund to promote the development of infrastructure. The key policy question is whether after that initial series of loans, using the initial federal capitalization of the bank is exhausted, and it's beginning to rely on that revolving interest from those projects, from those loans, does that mean that the new loans that are issued are non-federal funding? That is a question that policymakers have not determined yet. And so I think a big part of what we might see from the federal government in the next reauthorization bill really revolves around whether or not they are comfortable, whether or not our federal policymakers are comfortable making a determination that that type of financing assistance, after it's initially washed, is no longer federal. Because I think absent that, it becomes sort of duplicative or almost cannibalizing other types of federal financing tools. But Anne-Therese, do you have any other comments on that or about reauthorization generally?
I don't.
All right, Erin, just feel free to interrupt me as other questions go in. But I do want to, while we're on the topic of reauthorization, and Erin, you asked about kind of how some of these policy issues might ultimately wind up being addressed or not addressed in the next reauthorization cycle. I think it's helpful to step back for a minute. And I alluded to this briefly when we were talking about the NEVI program, which was authorized under the IIJA. The IIJA itself, just structurally, was incredibly unique and historic insofar as it included both a reauthorization of federal infrastructure programs, as well as an additional direct appropriation of funding for those infrastructure programs. So typically the way that a reauthorization program works is, the federal programs, they're all statutorily authorized. They are, Congress will pass a law authorizing funding levels, allocating the budget authority for those types of programs for a period of years. It could be 5 years, it could be 6 years, it could be shorter than that. And that sets the policy and also the funding levels. But every single year, Congress needs to actually provide the obligation authority through the appropriations bills for USDOT and the other federal agencies to actually allocate those funds that have been previously authorized. The distinction in the IIJA was that in addition to actually providing the authorization, the IIJA provided a direct appropriation of cash upfront for many of those programs, including the NEVI program. So that's why the funding actually exists currently. And as we talked about, the Senate FY26 appropriations bill doesn't touch it. The House FY26 appropriations bill in its current form would rescind that $1 billion in FY26 NEVI funding and move it to FAA for facilities and equipment. So I think I just wanted to provide some context because that is a very unique situation that we may not see in the next reauthorization cycle. I think what Congress, policymakers in Congress have been talking about is looking at a more historically traditional type of reauthorization that would really focus on policy and setting those funding levels for federal transportation infrastructure programs for a period of years. As a result, there's going to be probably less money to go around to kind of put into these, sort of, discrete areas. As a result, I think that's going to impact the type of policy discussion we're able to get into. This obviously has impacts on sort of political calculus. If you look at how things are aligned in the House and the Senate right now, I think, any betting money is on the need for a bipartisan bill, even out of the House, given the narrow majority that House Republicans have. We've seen a commitment from the leaders of the Transportation and Infrastructure Committee in the House to do a bipartisan bill. And as you're starting to get into the weeds a little bit on some of these issues, it really, I think, is important to think about it at that granular level when you're considering, like, what of the policies that we've talked about, what are the developments that we've talked about for the last hour could actually be put into law. versus done administratively or through the court system. So I will stop monologuing right now, but this is an area where I am quite passionate given sort of where I started my career. And if you have any specific questions, obviously, I mean, I know there have been more coming in, so Aaron, I'll turn it back over to you to kind of walk us through anything else. But as I said, I mean, Antrese, Aaron, and I would be happy to have further discussions with you about any of these topics. But
Sean,
Aaron, what else?
before we turn it back over
please.
to Aaron, one area that you and I have talked about extensively that falls into this category of changes that are out there, but that also have a statutory basis, and how our grant recipients should interpret changes to the programs that are based in statute, where we're getting directives that may be different. I'm specifically thinking about the DVE program, right? Yeah. It's statutory, the rebuttable presumption is statutorily based. There is the pending Mid-America lawsuit, but it has not, proceeded to any final determination at this point. But if we're reading the tea leaves regarding regulatory changes, of course, we have to wait and see what the regulatory changes are, but they may be removing that rebuttable presumption that is actually required by statute prior to there being some sort of final judicial determination. Do you have any thoughts on that?
Yeah, I mean, this is such a fascinating area, and in part, it's why we have kind of written extensively, and why you in particular, Antrese, have done other webinars specifically on this topic. Is it's really at the fulcrum of all three branches of government right now, and we don't have a final action from any one of them yet. I think we've been able to anticipate, in large part through your kind of sage guidance and tracking of this issue, where the court might go and how USDOT might respond. I think what is yet to be seen, obviously, is what is possible in a Congress that needs to act in a bipartisan way, just thinking pragmatically. To me, it just seems like it's going to be difficult to actually have Congress take a definitive action on this unless and until a court of competent jurisdiction makes a final determination on this topic. I just think until that cover is there, I don't know that Congress is going to want to touch it, but I've been wrong one or two times before, so maybe, we'll see.
Not since I've known you.
Thank you.
So yes, and I think that ties back to the Heyerholzer case that I was discussing during the presentation that has, like I said, been submitted for writ. We'll see if the Supreme Court takes it up, but this is a perfect example of, like you said, that confluence of the three branches of government and needing to work together among the branches to move forward in a way that doesn't offend any of the separation of powers.
Right.
Aaron, do we have any new questions?
Yes. Do you know about the recent retractions of discretionary funds that have happened over the last week or so? Like, is there any lawsuits relating to this?
Sean, do you want to start that, or do you want me to?
Yeah, thank you. I can see who that is from, and I would just ask that, if you have specific in mind, maybe you can just shoot us an email. I'm not sure if this is specifically kind of in reference to the Francis Scott Key Bridge, but I do think, as I noted, in all of these grant agreements, even the ones that have been executed and thereby obligated, by nature of incorporating the super circular into the terms of the grant agreement, the federal government retains a broad discretionary right to ultimately claw back the funding if it wants to. It obviously is not able to do that in a way that is probably without legal challenge, hence the question. I'm not aware of specific examples over the last week where the federal government has attempted to do that, and then there has been a lawsuit that has initially arisen as a result of that. But I would love to be made aware of that if it has existed. And Antrese, maybe you're more attuned to this than I am.
Yeah, thanks, Sean. So to your point, and I think the point of the person submitting the questions, it has been a fairly opaque process. We've been hearing that there have been some clawbacks, but really it's going to be something that we would need to look at on a case-by-case basis. As Sean mentioned, the super circular, as well as grant agreements like the master agreement from the FTA, has self-executing amendment clauses. And so even if there was a grant that came about under a prior master agreement, for example, at the Federal Transit Administration, these new policies and directives and certifications are now being included in the master agreement that is required to be certified to and signed off on by any federal grant recipient on an annual basis. So effectively, all of these new directives are incorporated into the grants by that self-executing clause. So to Sean's point, then you run into, if grantees are not in compliance with these requirements, these certifications, the federal government does have broad authority to terminate for non-compliance with the grant agreements. Now, there may be a case-by-case basis where that's not the reason why a grant was pulled back, but again, like I said, we'd want to look at that specifically, and so.
Yeah, the one thing I will add is, again, I would very much like to be made aware of these if I've overlooked them. But what we have seen so far is where the federal government has made an effort to either claw back funds, that are subject to an existing executed grant agreement, or have been otherwise appropriated, or a federal approval that might be required for a particular project. A lot of times the federal government has been pointing to specific deficiencies on the part of the project sponsor as the rationale for that. I think what we have not yet seen is that the federal government is just saying, it's in the public interest. We're determining that we're exercising our rights under 2 CFR 200.304, and we're terminating this grant for convenience. That I think would be new if that is what is happening.
And 200 CFR section 340.
Right. Yes. Thank you.
Aaron, I think we have a couple new questions, maybe one about DBE.
Yes, if a state DOT is continuing to administer its DBE program, is it susceptible to a CID before the Federal Highway Administration issues a new DBE regulations?
Possibly. So, you are in compliance with the regulations as they currently stand. It will really depend on what the Department of Justice's interpretation is of what the DEI programs, what DEI programs they're looking at. To date, I think they've been focused more on EEO programs as opposed to disadvantaged business enterprise programs, very likely because of, as we were discussing earlier, this issue where, none of the branches of government have actually moved forward in a way that gives, clear guidance on what's to come of the DBE program. But I certainly wouldn't want to rule out that a CID could come to any federal grantee for the purposes of the DBE program or any other DEI program in which it is engaged. As I mentioned, the letter that went to Governor Moore regarding the Francis Scott Key Bridge does specifically cite the diversity, equity, and inclusion programs related to the awarding of contracts. as a concern for USDOT, so it certainly is top of mind for the agency.
States have caveats and are litigating and have received preliminary injunctions in some cases to prevent clawbacks or refusals to go forward with grants.
Right, that's exactly right. And we addressed the three main cases that are addressing those issues earlier during the presentation. So as we mentioned, there's the King County case that's in the state of Washington. There's California versus USDOT that's based in the District of Rhode Island. And the latest case is the city of Seattle, also based in the Western District of Washington. All of those litigations are currently still, ongoing. There are preliminary injunctions in both King County as well as state of California to the point of the person who drafted the question. Those preliminary injunctions, are permitting those named plaintiffs to move forward without necessarily complying with the policies that we're talking about today. However, those injunctions apply only to the named plaintiffs. So there are many other plaintiffs out there that are not covered under those preliminary injunctions because the Supreme Court lifted nationwide or universal injunctions under the Trump versus Casa case.
Have any policy decisions been made regarding waiver processing? Is OMB reviewing BABA non-availability waiver requests for specific product types?
Yes, that is a great question. We did not get into domestic preference requirements, interesting as they may be, in part because there haven't been any notable policy developments with respect to the requirements for the Build America, Buy America Act, Buy America, Buy American, and other federal domestic preference requirements. However, I think I'm glad, I think this was one of the questions that was submitted in advance. I appreciate the person asking this question because it is a really important topic. One of the things that we've seen, it's not been a policy development, but it's certainly been an impact on this particular area and so many different areas of project sponsor and other professionals' interaction with the federal government is some of the staffing related issues at USDOT and across the federal agencies and within the White House. So to my knowledge, and I work fairly extensively in the area of supporting project sponsors and other participants with respect to domestic preference requirements. To my knowledge, there has not been a formal determination by the federal government that they're not going to, consider waiver requests. I think they are still considering waiver requests. I think the issue is the actual number of people available to actually review them, to consider the data, to follow up with the project sponsors or the other participants that are advancing this are very limited. And with the implementation of the Build America, Buy America Act in the IIJA, this has become a much more kind of process-heavy endeavor than was previously the case under the Buy America or Buy American regimes at USDOT, depending on the modal administration. So now, essentially, if you are advancing a BABA waiver under any rationale, whether it's non-availability or public interest or unreasonable cost, whatever your basis is, essentially that initial request will go to the operating administration with supporting documentation and review. There will likely be some back and forth communication to kind of hone the actual information and the rationale for the request. Then it will ultimately be reviewed, and if approved at the operating administration level, it will then get advanced to the secretary's office, where it'll go in another review. That's the easy part. The part that's become much more challenging has been with the implementation of BABA. Those reviews now need to go over to the Made in America office within OMB at the White House. There is extraordinarily limited staffing at the Made in America office right now that is available to actually review and process waiver requests. And so even without any kind of change in policy, these can still advance. Nobody's saying, kind of as a blanket no to advancing BABA waiver requests. The process heavy nature of it and the fact that there are limited individuals available to pay attention to and process and make progress on the consideration of these waiver requests has made it a really Byzantine endeavor. And as a result of that, I think it's not a viable option for many people to really assume that this is going to be something that you can just kind of build into the schedule, unless you've got years really to work on this. We have seen a couple of different situations where, there was a relatively minor foreign material that the project sponsor wanted to use on a particular project. Ultimately, it decided that it needed to pursue a waiver. As part of that consideration, the waiver request is ongoing, but the project sponsor is also considering, what are the alternatives? In this particular case, the domestic alternative just didn't perform as well as the foreign product that they were able to identify. So using a domestic alternative would actually require a redesign that would ultimately increase the cost of the project more than the actual underlying federal grant in monetary value. And so these are the types of considerations that project sponsors and other participants in the infrastructure space are just confronted with right now, because even absent any kind of, policy change, there are just a lot of questions about how, the federal government is able to actually process these things. What decision making is the federal government able to do that are necessary preconditions for project sponsors to make certain decisions. So I appreciate that question.
And it sounds like maybe we should do a Build America update, or I'm sorry, a Buy America update soon, Sean.
Yeah, that'd be a good idea. I mean, there certainly is a wide range of interest in this, not only in the transportation space, but I know public housing, and BABA, now is implemented government-wide in a way that provides sort of uniformity. But you still have these pre-existing additional domestic preference regimes like Buy America, like Buy American, that the federal government has determined are not superseded in every respect by BABA. And so you've got these like different layers. You've got, BABA that applies to everything. If it's a federal highway supported project, then you've also got to comply with Buy America with respect to certain of the materials that you're using on that project. FTA has their own rules, and on and on and on and on. And so, we've seen this come up on EPA, on MARAD, on housing under rural development. So it really is an extraordinarily wide area of interest, I think, that touches a lot of different parts of Americans' day-to-day lives.
So I think that's all of our questions that have been submitted, either in advance or via our question and answer portal. Sean, do you want to say anything, the overarching theme of this presentation and really what we're seeing in the questions, and we spoke to this specifically regarding DBE, but just generally the challenges that clients are having right now following, making the decision whether they're going to stick with following federal statutes and rules versus the reality of, we're getting these continuous policy updates. There's these executive orders that may sometimes give contrary or seemingly contrary direction than what's, currently in statute or in regulation. Any final thoughts on that challenge, and any recommendations to clients as they try to navigate this?
Yeah, so I'm smiling because I know you're, in the thick of this as well, Anne-Therese. And Erin, I know you've gotten pulled in many different directions on this topic. I think it really has to be analyzed on a case-by-case basis. And a lot of the projects that we've seen this come up in, do not exist in a vacuum. I mean, a lot of times, these project sponsors are, doing multiple mega projects or have other types of projects that are all wrapped up in the same issue. So immediately, as you're talking about it at a project specific level, it becomes a programmatic policy decision for the agency to make. And we've seen agencies take a variety of approaches because it ultimately does come down to sort of the programmatic decision making that needs to be done at the executive level and oftentimes at the board level. I mean, some of these issues are really important issues that people feel very strongly about, that different areas of the country, different environments around the country have different sort of positions on politically. And so, I think what we always strive to do and what we would encourage everyone on this meeting to do in their thinking is to try to be just as factual and objective as possible. Like, what are the existing requirements? What are the new requirements? How is this likely to change? What is currently pending? I mean, the OFCCP issues, updates to the regulations that I talked about earlier, these, when they're actually finalized, will have massive ramifications throughout every transportation project that involves construction. And so, staying on top of these, being vigilant as to the updates that are coming out of the administration, all of these things are really important to make sure that you are promulgating your capital programs in ways that are compliant with federal requirements, frankly. And, and we certainly endeavor to do that as kind of up to the minute as possible. I'm really interested in the discussion that we got into a little bit ago about potential actions that the federal government might be taking with respect to rescinding funding or terminating projects, terminating grants for existing projects without citing an existing kind of fault of the owner in so doing. I think that would be a really pertinent development to this whole discussion. But I think, just to kind of wrap things up in general, you need to stay on top of all this stuff, and you really need to think, as holistically as possible, because all of these are very hyper specific, but you can't just focus on one particular area because there's so many other things going on at the same time. I don't know, Anne-Therese, how do you think about that issue?
Yeah, as you know, since we work so closely together on this, we are of a like mind, and the goal is to always remain objective about, what the rules are, what the requirements are that are coming out of the administration, staying on top of it because it's moving at 1,000,000 miles per minute. It's maybe slowed down slightly since the onset of the administration in mid-January, but we're still seeing, changes to various policies, changes to various requirements, requests for various certifications still popping up. And to your point, it's really a risk analysis that needs to be done by the agency on a case-by-case basis. Once you are aware of the fact that there may be a requirement that, either conflicts with federal statute or regulation, or conflicts with a state law or a local ordinance, that's the time at which, to the point that Shant made, your executive team will, need to do that analysis of the risk associated with complying one way or the other.
Yeah. And one thing we didn't talk about, because we really tried to keep this as sort of national in scope as possible, but one thing that we haven't talked about at all is the fact that individual projects and individual sponsors have been receiving, sort of individualized direction from, U.S. Department of Transportation or other types of, or other federal equities. And so, there's that overlay as well. I mean, there may be a project specific or an owner specific directive that kind of overlays on top of all of the stuff that we've already talked about, and that would be obviously specific just to that particular agency or project. But, I think in general, I think what we have, hopefully this has come through, and not in a way that's necessarily overwhelming, but this is really complicated. There's a lot of complex things happening that all implicate each other. And I think navigating them effectively is going to be key to having a successful capital program and working effectively to navigate our way through some of the question marks that we've got right now. But let me just take one more opportunity to thank everyone for your time today. We are tremendously appreciative that you have spent 90 minutes here with us talking about what we think are really important and interesting issues. I want to thank Ann-Therese and Erin for your time. Please, as I mentioned before, our contact information is here. Please, we would love to hear from you if you have specific questions. If what we said didn't make sense, or if you disagree with it, let's continue the conversation. But please be on the lookout for an email with a survey, links to download the slide deck and the presentation, and we're looking forward to seeing you next time. Thank you very much.